All right, well, good afternoon, everyone. Welcome to Personal Risk Management for In-House Counsel. We're going to go ahead and get started now, and we'll start out with some introductions. So my name is Erica Villanueva. I'm a partner in Farella's insurance recovery practice, and I'm also in the financial services industry group. And I have been practicing in this area for 15 years, representing exclusively policyholders in insurance recovery negotiations and disputes against commercial lines insurers, with a particular focus on financial lines, which includes the insurance coverages that we'll talk about a little bit more in this presentation, directors and officers liability, also sometimes known as management liability, and we'll also talk about a little bit about employment practices liability.
My name is Joshua Malone. I am an attorney with our white collar practice group. We specialize, I think, in kind of SEC, DOJ investigations, particularly focused on pool counsel, representing individuals when conflicts arise, and as well as internal investigations. And we balance that out with a little bit of commercial later on the side. So.
My name is Carolina de Armas, and I'm in the corporate group, the business transactions group, and I'm also in the renewable energy practice industry group and the consumer products industry group.
So I'll get us started here. As you can see, so the first bullet says, so just as a kind of introduction, broad level of what we're going to talk about. So risks to in-house counsel, I presume most of you, and compliance personnel when compliance failures occur. So just to set the stage of kind of what we view, the typical problem or kind of the emblematic problem to be is, say the SEC or DOJ comes knocking or the company has occasion to initiate an internal investigation of some kind. You work in the legal department and you don't know exactly what went wrong or who's at fault, but you gave advice to every single person who might be the subject or potential witness of this investigation. So you're wondering, okay, am I going to be okay? What does this mean for me? Am I going to be in hot water? So a typical example of this from the real world that I think I can point to, a couple of years ago, and this is all public, what I'm about to share, we represented Yahoo with respect to a couple of the massive data breaches that they had. It was basically his background. I think it was finally disclosed in 2016 after internal investigation. It was discovered that these breaches occurred a couple years earlier, 2014, and the kind of, I think if you could say like if someone's head was on the platter, it was the in-house legal department. It was written in some public reports that they had information regarding the severity of the breaches much sooner than it was disclosed. And they didn't do enough at the time. So following this big, I think, kind of corporate kind of extravaganza I read about in the newspapers and I see it on TV, the person who I think was ultimately most held accountable was their general counsel, Ron Bell, who was kind of pushed out the door and he resigned. So that is kind of the worst case scenario, and what we're trying to have not happen as we give some best practices and as we talk about some indemnification and D&O coverage to make sure we're financially on the right foot. So turn it over.
Okay, so the first way you're protected is through indemnification, which is an undertaking by your employer to pay or reimburse the cost of legal expenses and liability. And you'll find the indemnification protections in the employer's articles and bylaws or in an indemnification agreement if you have one with your employer. And at a minimum, you might be covered under the statute. And
we'll also talk about whether you're covered under the statute or not. the coverage that may be available under your employer or former employer's insurance policy. So we will talk about insurance. I promise it's not going to be bad. I promise it won't be boring. I will make it interesting.
Okay, so a major theme, I think, of what I'll be talking about is, and it was mentioned on the previous slide, is don't be reticent as in-house counsel to seek and obtain your own separate legal counsel. I think as we look at some of these personal consequences and corporate consequences of what happens when there's alleged corporate misconduct, it will, I think, be, maybe not always commonplace, but I think there's a material risk that you could be held accountable for something that ultimately that you were not ultimately responsible for. So if you look at starting below the corporate consequences that are listed here, activists, negative publicity, stock price declines, all of these things, I think, in conjunction, that put pressure on companies, particularly public companies, to react and do something to remedy corporate misconduct can lead to the top bullet point, which says corporate reorganization, change, and control. And I mention that because, returning to the Yahoo example, all of those things did, in fact, occur, activists, negative publicity, and the end result was this corporate reorganization to the point where Mr. Bell, the one who ultimately resigned, maybe the people as in-house counsel who you think might have your back, who are on the board or in the C-suite, might not be the people who are ultimately making the decision about your employment at the end of the day. So, and the personal consequences, I don't think it's too much to say or to be too alarmist, but that's everything: job, reputation, financial impacts, and civil suits. I haven't found terribly recent statistics on this online, but I found some about a decade prior. Then just like a 3-year span, the SEC had instituted something like 75 enforcement actions against attorneys. So this is not something that I think is to be taken lightly, and something we should prepare for. So,
I don't want to interrupt your flow, but to what extent is the GC or the lawyer staff the sacrificial lamb? I mean, the corporation has bungled seriously, and isn't it just easy to get rid of GC or legal team and say we're done, it's all their fault, so that you protect everybody else? I mean, is there a dynamic there we're talking about?
yeah, and we will, and I think that's actually kind of a central subject to what we will be talking about, because there will be many cases where, so say you're not in legal, and you are being investigated by the government, and they say, why did you do X? And I think the natural inclination is to say, well, in-house told me that it was okay. Or the DOJ or SEC or whomever might say, might look at not just the provision of bad legal advice, but they say you didn't do enough. You actually didn't correct the problem when it should have been corrected. You didn't actually speak up and say enough. So again, I don't want to be too alarmist, but I think looking at previous examples, we've looked at Yahoo. There's also Wells Fargo, Volkswagen. In-house legal often does have to pay a very public and heavy price when these investigations do occur. So that's responsive.
Okay, so turning to indemnification, I'm going to talk about the minimum amount that you're going to be covered under the statute, and then we're going to talk about how your company can go above and beyond to cover you in bylaws and articles or in an indemnification agreement. So the minimum amount of protection you're going to get in Delaware and California is reimbursement for expenses if you as an agent are successful in your defense of a legal claim. So in Delaware, they're not required to reimburse you if you're just an employee. The minimum is for directors and officers. And to be safe, directors and officers are people appointed by the board or the stockholders, and an officer that falls under the description of an officer in the bylaws. So there's been some case law where if you're an employee and you've got the title vice president, but your day-to-day responsibilities aren't that of one of the executive officers, you may not be covered if your corporation is a Delaware corp. In California, you are covered. An agent includes an employee as well as a director and an officer. And it also includes people serving at the request of the corporation, which would cover directors and officers of a subsidiary. If that subsidiary doesn't have indemnification provisions, you could look to the parent company's org docs, and you might get protection there. Another thing to note, in the minimum amount that you're covered under the statute is that it's just reimbursement, so you have to cover all the fees until you get to the end of the proceeding, and then they'll reimburse you. But most employer articles and bylaws will go beyond the minimum. And in order to be able to take advantage of those extra indemnification provisions, you have to have met a certain standard of conduct. In California, that conduct is the action has to be in the best interests of the company or the stockholders. In Delaware, you have more leeway as long as your actions aren't opposed to the best interests of the company or the stockholders, you're fine. They have to make a determination that you've met that standard of conduct in order for you to take advantage of the extra indemnification provisions. So for example, if you're not successful in your claim, but you meet the standard of conduct, you're going to be able to get indemnified if your corporation has that built into their org docs. And the determination comes from the directors can make the determination if they're not also involved in the indemnification proceeding. A committee of directors, the stockholders, independent counsel, or in California, the courts can make the determination if you've met the standard of conduct.
So I see that it's in the law. You don't have it built into your bylaws. Does it still apply?
The standard of conduct, or
Yeah, like, so if we don't have anything in our bylaws talking about indemnification and something goes down, will I be able to point to this law and say, hey, this indemnification is going to apply regardless, even if I win on the merits or if I don't meet the this?
so you can only point to the statute if you are successful. In Delaware, success means successful on the merits or otherwise. So if the case is dismissed, counts as a success. In California, you have to be successful on the merits. If you aren't, then and your articles and bylaws are silent and you don't have an indemnification agreement, you're going to have to look outside the corporate statute. One example is this California Labor Code 2802, which says that an employer has to indemnify you for any necessary expenditures or losses that you incurred in the scope of employment. But a couple wrinkles here. In indemnification, your expenses only have to be reasonable. Here, they have to be necessary, so that's a higher standard. And this only works if you, for example, work for a Delaware corp in California. If you're not in California, you could look under agency law for some kind of protection similar to this, but these are two places to look outside of the corporate statute. Okay, so the first place you're going to look to see what kind of protections you've got are your articles and bylaws of your employer company. One thing to note in California, for your California corporation to give any provisions in excess of the minimum, it has to be authorized in the articles. If there's no language in the articles authorizing more indemnification than the minimum, it might not be upheld even if it's in the bylaws. And another thing that you should look out for in your articles and bylaws is language about retroactive changes. So indemnification is going to cover you after you leave your position or you retire for any actions you took while in office. But if there's language in the articles or bylaws that say that the company can make retroactive changes to the indemnification provisions, then you might think you're protected to some extent, but you leave, they could change it, and you're not as protected as you thought. You might have to go out of pocket and pay to cover your expenses until you can prove that you were due indemnification. So outside of the bylaws and articles, you can get protection through an indemnification agreement, and these aren't that common if you aren't a high-level executive, but if you're up for a promotion or you're going to take a job or you're taking on more legal risk, you might consider asking for one because they provide a degree of comfort that you don't get from the more generalized provisions that are in your articles and bylaws. For example, if you're working for a Delaware corporation and you're not sure that you fall under the description of an officer under the bylaws and your corporation only covers directors and officers, if you get an indemnification agreement, then you're going to be covered. So I was just going to run through a couple of key provisions in the indemnification agreements. One is advancement. That ensures that you don't have to wait until the end of the proceeding in order to get paid back for all the money that you expended defending yourself. And another important thing about advancement is that the employee usually has the burden to prove that the expenses were reasonable. But in an indemnification agreement, you can put in a provision that says any advancement is presumed reasonable. So when this claim happens, you don't have to be worrying about proving what you're doing is reasonable. You can just get it covered and then at the end figure out, how it went out. Another important provision in your indemnification agreement is standard of conduct. So that standard of conduct determination that you have to go through in order to get covered if you're not successful, you can require that the company make the determination within a certain period of time, and if they don't make it in that time frame, you're presumed to have acted within the standard of conduct. And then finally, you can request that fees on fees are included in your indemnification, which indemnification technically just covers any expenses in defense of a claim, so you have to be the defendant. If you have to go after your company to get them to indemnify you, it might not be covered under your typical indemnification provision, so you want to make sure your agreement covers any expenses of enforcing your indemnification rights. And then the last thing I wanted to flag is that even if you have a really good indemnification agreement with lots of robust provisions, it's only as good as your company's ability to pay. So if your company is in financial trouble, which happens a lot, you might not get paid out even if you have a strong indemnification agreement.
Which brings us to insurance. And again, it's more interesting than you might think. So I'm going to talk about D&O insurance, but I think it's useful as I go through the points on this slide and the features of D&O liability insurance to talk about when they're the same and when they're different from employment practices liability insurance. Because, in the examples we've given so far and the sort of the paradigmatic scenario that Josh set up, you're mostly talking about, securities class actions or DOJ investigation, SEC investigation, things that would fall under a D&O policy. But as you know from working in in-house legal, you also can get involved in claims that will implicate employment issues. And there's a lot covered today under employment practices policies. It also includes coverage for liability arising out of things like workplace violence and active shooters. It covers discrimination claims by customers or business invitees, not just claims by employees. So there's a lot going on these days in the world of employment practices. So let's just talk about, are you an insured person? Are you, as an in-house employed lawyer, are you an insured person under the policy? And the answer, as in so many things for insurance, is it depends. It depends primarily on whether or not the company is a public company or a private one, and it also depends on the type of claim. So what most people think of as D&O liability insurance really comes in two flavors, and the traditional D&O insurance is what is sold to public companies that are publicly traded. Private companies have a different product called management liability insurance. it's really important for you as an employed lawyer to understand what type of coverage you have, and particularly to understand your coverage well if you're a private company, because the coverage for regular old employees, not just directors and officers, is much broader under a management liability policy than it is under a public company D&O policy. Under a public company D&O policy, you're only going to be covered as an employee if the claim is a securities claim. But if you are a private company, if you work for a private company, the coverage is much broader, and it will generally extend to employees. I will caveat that in the public company context, there is sometimes endorsements on the policies called employed lawyers endorsements that will specifically wrap in coverage for in-house counsel. So again, something that's good to understand, what your policy looks like. Another thing I'll say, and I thought that this might have been self-evident until I gave this presentation once before, and someone raised their hand and said, well, if I get subpoenaed and it has to do with my former employer, well, there's no coverage for that, right? Because I don't work for them anymore. Wrong. The definition of an insured person includes past, present, and future insured persons. So if you're in the process of onboarding, you're an insured person. If you've left the company, but you get a subpoena that has to do, or you're named in a lawsuit that has to do with your conduct during your time at that company, you're an insured person under that company's D&O insurance. You're not an insured person under your current employer's D&O insurance, because the conduct that's being alleged has to do with your old capacity, your former capacity. And then the last thing I'll say in terms of comparison to employment practices is that basically everything I've just run through here with respect to private company D&O insurance is exactly the same for employment practices liability, whether or not you're a public or a private company. All employees are covered, and it'll be a fairly broad coverage. So we all know that we have to report claims under the policy to an insurer, but when have you received a claim? And the hint here is, oh, it's a lot sooner than you think. So let's talk about how D&O coverage operates, what the trigger of coverage is. The trigger of coverage is a capital C claim, and it has to be both first made and reported to the insurer within the same policy period. And if employed lawyers knew nothing else about the D&O coverage that applies to them, my one dream and wish for all of them is that they would know what the policy's definition of claim is. Because it's very often that the very first element of the definition is a written demand for monetary or non-monetary relief. That's it. No lawsuit. Yes, that means an email. A written demand for monetary or non-monetary relief. And so, classic situation we see all the time. There's some demand letter or something put out in policy year 1. Nobody thinks it's a big deal. Shrug it off. Policy year 2, it becomes a big deal. You now have something that was a capital C claim in policy year 1 that you didn't report in policy year 1. You reported it in policy year 2. It means there's no coverage for that claim for anybody under either policy year. And nobody wants that. So now that I've scared everyone to death, I will point out that there are all sorts of caveats and grace periods built in to these reporting requirements. So usually it's very common that you'll see not just, you have to report it by the end of the policy period, but 90 days, you could have up to 90 days after the end of the policy period, although this really varies. It's getting very common now, particularly in public company D&O, that you'll see a prejudice standard built in, which is something that didn't used to be the case, but you're starting to see more and more that that rule that I just described will still apply, but there'll be a clause that says, provided, however, that the carrier won't be able to deny coverage unless they can show that they've been prejudiced by the late notice. And all these rules, by the way, and these sort of very draconian rules about reporting, they apply equally to employment practices liability. So why am I telling you in the context of, a presentation that is for you and about your own personal protection, not about protecting the company? Why am I telling you all about these potential consequences of late notice? Because when you find out that you've been implicated by any type of proceeding that you think might be a capital C claim under your company's insurance policies, you should ask for a copy of the policy, make sure you understand and make your own independent determination of whether or not something is a claim. If you have left the company or if you're still at the company and if you're demanding indemnification, part of that should be to ask for a copy of the insurance policy, ask for the company to confirm that they're reporting the issue to the insurer on your behalf, and get a copy of that notice to the insurer. These things are your sort of insurance policies, your personal insurance policies, to make sure that claims reporting is being handled correctly. And it is, I know from personal experience representing clients, it is much easier at the outset of some investigation or litigation to ask for these things before it becomes awkward. If you ask for them right up front, it's just as a matter of course. It's much easier than when the situation may have soured or become more acrimonious. Let's talk a little bit about your defense costs. Are defense costs covered before you get insurer consent? Short answer is no. Although as a practical matter, usually what happens is the carrier treats the date of notice as the date you asked for consent to everything, so you'll be covered from that date forward. And again, this is the same for employment practices liability. Now, there's a very big difference in the world of D&O policies between duty to defend policies and duty to pay defense cost policies. And you may hear that and think, that just sounds like semantics. Unfortunately, that tiny little wording, differentiation makes a huge difference in what type of coverage you're entitled to. A duty to defend policy in California gives the insurance company the right to cap the rates. And their idea of what reasonable rates are does not comport with normal day-to-day reality, especially not in the Bay Area. It's very typical that you'll see in the D&O context wanting to hold all defense counsel to $450 an hour, $550 an hour. In the employment context, it'll be even lower. It'll be $295 an hour, $350 an hour. In a policy that puts the duty to defend on the policyholder and only takes on the obligation to reimburse defense costs, insurance companies don't have that right. So it's important to understand what kind of policy you're dealing with here, and whether if you go out, as we're going to talk about, if you go out and get your own counsel, understanding that you're going to be how much of a shortfall are you going to have between what the carrier is going to cover and what you may be incurring in personal defense costs. And I'll say on the EPL side, on the employment practices side, almost all the policies are duty to defend policies. So almost all give the right to cap rates. Even if you're in a duty to pay world, the carrier will say it's entitled to allocate between covered and non-covered claims. This is another sort of trap for the unwary. I will say that for you all as individuals, you're less likely to fall into this trap because there's generally more protections in most policies for individuals, and more claims are covered for individuals than they are for the company. So, it may be in some ways easier for you to have your own counsel than to be defended by the company's counsel, because the carrier, if you're defended separately, the carrier will have to agree to pay for all of your fee, of your defense fees. Side A coverage, you hear about this a lot. What is this? So it's separate, extra, dedicated limits that are only for individual insureds. And in public company D&O, these can be quite high because the board demands it. And so you could have a potential huge additional pot of resources that if you're, named side by side together with other Ds and Os in, for example, securities case, you also have access to that money. If you're in the private company space, the separate side A limits are usually pretty low. It's usually about an extra $500,000, and that can go very quickly in an investigation. So let's talk briefly about investigations. Are they covered? Answer, it depends. Again, the distinction will depend a lot on whether or not it is a public or a private entity. Private is going to have fairly limited investigation coverage and only for insured persons. Public company will be a little more robust, and there are a lot of different nuances and bells and whistles. I won't attempt to summarize them all because what you should just know about investigations is that the coverage is very non-standard, and you shouldn't take somebody else's word for it that, oh, investigation isn't covered, or, oh, it's definitely covered. You'll want to look at it for yourself because the coverage varies widely. I will say the biggest thing that trips people up is they think, well, I got a subpoena. Of course, this is a covered capital C claim. But the subpoena might just say, in re, name of your company. There's no indication that you personally are under investigation. There's no indication of who the targets are. And of course, at that point, nobody wants to ask because you're afraid, nobody wants to ask the government, am I a target? Because they're concerned the answer will be yes. So even though you have what in a lot of respects looks like a claim, you may not have one because the insurance company will say, well, it's not an investigation of you. It's not for a wrongful act of you. It's just sort of a general investigation. So that can be a trap for the unwary. Finally, I'll say something about the so-called conduct exclusions. If this has been done right by your company, the exclusions in the policy for intentional conduct, for fraud, for disgorgement of ill-gotten gain and things like this, they will be contingent on a final non-appealable adjudication in the proceeding in which you're currently facing that allegation. That is the gold standard language. It is rapidly becoming the most common language. If your company doesn't have it, they should get it. Their broker should ask for it, and frankly, their broker probably isn't doing a very good job if they haven't gotten that language for you already. Because there should be, nobody in here should probably be covered under a D&O policy that would give the insurance company the right to refuse to cover you just because there's a mere allegation that you've committed an intentional conduct. And the exclusions should also be fully severable. What does that mean? It means that the wrongful conduct of one person should not be imputed to any other person. If it's done right, it should be what's called full severability. Often they'll have one key person, usually the CEO or the CFO. Their knowledge will be imputed to the company, but everybody else should be fully severable and should still have their coverage, even if some person is the bad actor. And ideally, the person whose bad knowledge should be, can be imputed to the company should not be the general counsel, because then where does that stop, right? In terms of, well, then it gets imputed to other folks in legal as well. So I've said everything I need to say about insurance. It might have been more boring than I promised. For that, I apologize. It was interesting to me. So with that, I'll turn it back over to Josh to talk about the white collar stuff that you're all here for.
So going to the top point, know your indemnity and D&O coverage positions in advance of a crisis. So this partly hits on some of what Erica was talking about making sure claims are reported, obviously, with sufficient notice. And if you don't think that applies to you, it also helps with indemnity as well. It gives you time and a little bit more leverage to maybe negotiate that indemnification agreement if you don't have it. If you're waiting for the crisis to hit, and then you're asking, the company might raise some eyebrows and say, it certainly seems like there might be a conflict between this person and the company. I wonder why they're asking now. Maybe makes them a little more reticent to pony up. And we recently had a client who was not counsel, but he was a subject/target of an investigation. He thought he might have been covered by his company's bylaws. He wasn't. And there was this big, long, wasted process where he tried to see, okay, does 2802 apply to me? What is 2802? Then he tries to go back and forth with his employer about whether or not they'll cover him under 2802. All the while, the government is trying to beat down his door and interview him. It was a big, long, wasted process, and it helps to actually be a little bit prepared, obviously, in advance. So when your responsibility expands, consider seeking expanded protection. So I think this is just a little bit about knowing your worth to the company and realizing that as counsel, as you progress in your career, get a little bit more senior, you're supervising more people, and maybe you're making more significant legal calls, your level of risk is rising as your value to the company is rising at the same time. So again, this is a little bit more leverage for you. We had to do this on the 2802 case, but with respect to selling it to the company. So you might have to feel like, okay, so how would I even try to seek expanded protections? How would I even try to ask for an indemnification agreement? Because they are pretty, they're not common. And I think one thing that maybe might assuage some concerns with the company is that if you have counsel who is maybe asserting privilege and telling you not to answer something, that carries more credibility if it's coming from your counsel than the company counsel, because there's obviously much less concern that the company is trying to influence your testimony. And just the fact that you're having separate counsel versus company counsel prepare you for that interview, I think that carries more credibility as well. And with respect to, I think it helps the company to maybe be reminded that there is usually a free flow of information. There's joint defense agreements between separate counsel often and company counsel, as separate counsel often needs the documents and information that is in the possession of company counsel. It assists both sides. They're both aware of what's going on. It helps them retain top talent. And for companies, for in-house counsel who are worried about the extent of their coverage, I think it has a couple pretty negative side effects. Is one, it might make counsel maybe a little too conservative in their legal advice. If they think that there's some level of risk, maybe they just always hedge on the side of maybe just don't do that thing that might be problematic. And two is, and we'll get to this later, with respect to whistleblowing, is just being trigger happy and just reporting everything that you think might have implicated you because you don't want to get in trouble. And those are both things that companies obviously don't want to have to worry about. So when joining a new company, consider its indemnity and D&O posture. Kind of similar to what we've been saying, you have your pro-con list when you're thinking about taking a new job, like salary, location, level of responsibility. This can be on your list, maybe not as important as those things to most people, but it can be on the list nonetheless. And don't go in represented, including an internal investigation. If you're an employee and you hear what is referred to as the Upjohn warning, which is basically along the lines of, we are company counsel, we're not your counsel. What you say may be privileged, it's the company's privilege, and we can decide to waive it, and you have no say in that. You should run, because that is them telling you that, hey, we're, like I said, not your counsel, and you are not our client. And then you should run and get your own separate counsel. Just as it would be hard to imagine you sitting down in an investigation or an interview with the DOJ or the SEC alone without counsel, that might be effectively what you are doing by not engaging separate counsel in these interviews with company counsel, because they can decide to just pass along whatever you're saying to the SEC or DOJ, and you would have no control over that. So, and it kind of goes back to, I think, what we were saying too, like maybe oh, thank you, Erica. The fear that as in-house counsel, you might be the sacrificial lamb when something goes wrong. So just some tips maybe to keep yourself prophylactically from getting in trouble in the first place. Mindfully document advice to internal clients. I think the key is to do it mindfully. I think you are busy people who are getting phone calls and in meetings, and you're dispensing legal advice all the time. It's not like you can write a memo to file every time you give legal advice. But maybe for more sensitive calls, it's just a CYA, right? So you can point to something and say, no, this person is actually maybe misrepresenting what I said, or I actually did say something when someone said I didn't. Avoid selective use of communication channels. I think nothing gets the government's attention, obviously, as much as reading an email and then someone writes, let's take this offline, or let's text, or let's take it to WhatsApp, which happens far more commonly than you would think. Or
Maybe even by current members of the administration.
yes, right. It's probably the subject of another MCLE, but if you happen to work at a company that doesn't have clear policies about the use of ephemeral messaging apps and non-email communication like just iMessage text, and what communications are appropriate when, I think it's worth reminding your compliance personnel to get on it. Because even if it's not something that's obvious, like let's take this offline, if there's just an arbitrary back and forth of going between different mediums to communicate, not only, there's a real risk that this loses potentially exculpatory data, documents for you and for the company. That's something that you could have pointed to that you no longer can. And from the government's perspective, when there is missing information and they see that people have been communicating on non-email channels that can't be easily retained, or even something like Slack can be easily retained, so something like iMessage or WhatsApp, there is the presumption, naturally, of wrongdoing. They will just go straight to something is fishy, and you will not get the benefit of the doubt. So the third point, ensure adequate legal staffing in key risk areas. I think this was maybe not obvious when you read it, but I think what's happening here, and it goes back to kind of our typical, maybe not typical, but the big example I keep referring to, which is Yahoo. So in that case, data breach case, obviously, so cybersecurity, big risk area, there are communication gaps between counsel and oftentimes these areas in the company that go wrong, like cybersecurity. And if maybe say the engineers who are trying to communicate the severity of a data breach is using jargon that doesn't make sense to in-house counsel. In-house counsel can't adequately assess, I guess, what to do or what the appropriate response should be. Maybe that's similar in maybe financial institutions as well. So it's just about filling those communication gaps. Think about how to track on-the-fly advice and analysis. This goes to kind of something similar before, which was just keep track of some of the more sensitive advice that you're giving. And then don't go it alone. Not much to say here that isn't stated. I think there's an old adage, if you're going to make a mistake, do it with someone else, don't do it alone. It's consult outside counsel on close calls at the end of the day. Exercise care in all forms of communication. So I think at the end of the day, it kind of goes back to Upjohn. The company and not you has the discretion about when to waive privilege, so you need to just assume that everything that you're putting in writing might end up on the front page of the Wall Street Journal, and you might need to just think about how that looks ahead of time. And blowing the whistle, there are, if you need to and do it right, there are often internal company policies about the proper procedures that you should obviously become familiar with. But this is a fraught enough area that you should seek outside counsel who can guide you through that process. So looking at this, the State Bar of California, I think last year, updated their rules about whistleblowing, and particularly with respect to in-house counsel, and that's Rule 1.13. And there's, I think, a few key points to I think, take away. I won't bore you too much with it. I think the big change is that when an organization's lawyer knows that there's an intent to violate the law or someone already has, you must now report to a higher authority within that organization. It gave counsel discretion to do that before. But to maybe limit maybe the kind of the willy-nilly, just everyone just reporting everything because they're obligated to and they don't want to run afoul of anything. There's a heightened knowledge requirement. You must know a violation of law imputable to the org exists and that it will result in substantial injury to the organization. When reporting to the head of the org, I think at the end of the day, the ability to report out is limited. Basically, and this is partly why it's sometimes important to engage outside counsel, because there's thorny intersections between your desire to want to cover your own self versus these conflicting duties of loyalty and confidentiality that you owe to your client. So while you can report up, taking it to the regulatory authority is often something that you cannot do. And last bit, for the people who work in publicly traded companies, this is SOX, the reporting up requirement. I guess the big takeaway here is that it kind of puts an additional layer on what your obligations are about when you think that there is a material violation, reasonably likely a material violation of security laws. You report to your CEO and or your chief legal officer, but then your duties don't stop. Then it's now their obligation to investigate, and then if you have some kind of reasonable belief that the investigation was inadequate, then you report the information higher up if you can, audit committee, board of directors. And failing to do so carries some risk of civil penalties and other bad stuff. So I believe that we only have 10 minutes left. We wanted to open it up to questions just in case.
I know everybody's here with all their insurance questions. Yes, I know.
So I have a question, maybe the answer is obvious. So the lawyer performs legal analysis
No, it typically doesn't. So that's separate, but the kind of exposures that you're facing are usually not of the legal malpractice variety. They're not by your client for providing bad advice. They're by a third party for other conduct giving rise to liability to the third party or to some type of criminal or regulatory violation. So it isn't really an issue of legal malpractice, and that's usually carved out of D&O policies pretty explicitly. There can be some coverage for malpractice-like liability if you have employed lawyers as an endorsement on your policy. And again, you tend to see that more in the public company D&O policy. Where you tend to see that get triggered more is really on the transactional side, when there's a claim after the fact about advice given in connection with a deal. But it doesn't really actually come up in the true professional negligence malpractice context, the claims that folks in this room would be facing, and they're not covered under traditional D&O typically.
If you're a company and they don't have indemnity agreements, is it not like really easy to sell these? I mean, if you went to any of your executives or your board and say, hey, let's do indemnity agreements, and everybody like sign me up, like who doesn't want these?
I don't think anybody doesn't want them. Usually they would I think it's if you have a big company and you have a bunch of lower level employees, I haven't seen it where you have indemnification agreements with all of your employees. Usually it's just your executive officers and your directors, and they'll definitely want an indemnification agreement. But if you get a promotion, it seems reasonable if you're worried about it and you don't feel like you're adequately covered under your bylaws to ask. There's no harm in asking.
Said every lawyer ever.
Well, so I glean from your comments that there are scenarios in which the lawyer ends up having to pay for his or her own legal defense costs and costs of the lawsuits or claims overall when insurance makes its fine-tuned analyses that coverage doesn't apply. So does that happen often? I mean, is it a real issue?
I will say that lawyers don't get named as, I haven't seen as many claims where the in-house lawyer is getting named. If they're not covered, it's usually because it's falling within the cracks in terms of these investigations, because you'll see them often as witnesses in investigations, and they then fall into these nuances that I was talking about that aren't worth getting into in too much specifics because the language varies so much from policy to policy in terms of the investigations coverage. But I think that's when it goes back to whether it's covered or not. There are a lot of good reasons that the company will have in its own interests to make sure that its in-house counsel have representation. Whether they will kick in for separate counsel from the company is perhaps perhaps a different story, but certainly making sure that their own, the folks who on the exposure generating issue were providing the legal advice. I think at the end of the day, most companies, regardless of what D&O ends up doing, will make the call that they need to give adequate protection to the folks who provided the advice. So there usually doesn't end up being a gap, but it isn't always covered by insurance, is my experience. I don't know if Josh, you had anything really to add to that.
No.
Other questions or comments? I have seen that occasionally. This is one of these interesting things where sometimes the definition of D's and O's under the insurance policy can be better and more helpful than, internally they don't want to say that they have too many people that are true C-suite. But sometimes the D&O language is a little more ambiguous, and so it'll include, for example, folks who are considered directors or officers of subsidiaries. And there are lots of times where employees, there might be some subsidiary that is, has its own set of officers and even a board, but it's not considered, like the true C-suite of the company, but those folks could be considered D's and O's within the context of the insurance policy. So it's very policy language specific. Well, it's been fun, everyone. I hope that everybody isn't leaving here too terrified and freaked out. If any of these situations comes your way, feel free to call me. I'd be happy to beat up on your insurance company.